Hi, my name is Gilbert Ambler, and I'm a firearms attorney at Ambler Law Offices. And today I want to talk about an abrasive new rule released by the ATF. And although I'm joking about a little bit with that term, an abrasive rule, it's actually a very, very serious matter. Because what the ATF has done has redefined up to 40 million braced pistols as short-barreled rifles. And the distinction here is huge, because a braced pistol is an item that is affixed to the rear of a pistol that helps the shooter shoot the pistol with one hand. So often it would be strapped to a forearm, it would help stabilize a heavier pistol, it might have helped a disabled shooter manage a weapon. An SBR, or a short-barreled rifle, is a federally controlled firearm, okay? And the penalties for possession of an unregistered SBR are very, very serious. Possession of an unregistered SBR is punishable by up to 10 years in federal prison and a fine of up to $250,000. It's a federal felony. So what the ATF has done through their reclassification has taken perfectly lawful braced pistols and redefined them as items that could land you in prison for up to 10 years, okay? And I should define the term an SBR a little bit further. This short-barreled rifle, it applies to a rifle, an object that is designed and intended to be fired from the shoulder, that has a barrel length of under 16 inches or an overall length of under 26 inches. Now this is where it gets interesting, because handguns, typically intended to be fired from one hand, and the brace could be affixed, and as I said, that brace would help a shooter stabilize a heavier handgun. But the ATF has been concerned that people might actually be taking these braces and putting the braces up to their shoulder. And this has been an ongoing concern for the ATF. At one point, the ATF had taken the position that you could legally put a brace on a pistol, but that if you ever put the brace against your shoulder, it made an illegal SBR. They retreated from that position. And since they retreated from that position, many braced pistols have been sold. And as I said, I referenced an estimate of up to 40 million of these items. In 2021, the ATF proposed a new rule for braced pistols, and it was a factoring criteria. It was a worksheet. And the intent behind this worksheet was that it was supposed to help you determine whether a braced pistol that you had was really more like a short-barreled rifle, whether what was affixed to the rear of the pistol was really a stock in the eyes of the ATF. In response to this proposed rule, many individuals and organizations wrote criticism of this proposed rule to the ATF, and the ATF looked at that criticism, and then yesterday, in early January of 2023, they released the final rule. The final rule says this: it does away with that factoring criteria worksheet. Instead of the factoring criteria worksheet, what they have is they've listed criteria with far more ambiguity that they think tends to indicate that a braced pistol is not really a braced pistol, but would instead be an illegal SBR. And some of the criteria they're looking at: the overall weight and length of the pistol, the length of pull, how far it is to the trigger, to where you need to pull the trigger from where you hold the weapon, the eye relief, whether you've got optics or sights on that have eye relief, typically associated with rifles, whether the shoulderable area, whether the portion at the rear of the weapon is suitable for being placed against your shoulder, marketing, if the brace is being sold and marketed, and in the marketing it shows people placing the braced pistol against their shoulder, and then finally, the most broad category of all, the general likelihood that the weapon gets used as a SBR or as a braced pistol in the general community. And so are people actually using it as a brace, or are they placing it against their shoulder and using it as a weapon? What does this mean? It means even if you buy a braced pistol and use it properly, if the ATF thinks others in the firearm community are using it illegally, placing it against their shoulder, which the ATF is saying makes a short-barreled rifle, then they're going to consider it an SBR either way. And as I said, the penalties for this very serious, up to 10 years in prison. So the ATF has given you some options. They said, look, we think that all these braced pistols out here are in fact illegal SBRs, but you have some options. The first option that they're giving you is to register your previously possessed, lawfully possessed braced pistol, to now register it with the ATF as an SBR. The issue with this registration is several things. Number one, if the item is in fact an SBR, if the ATF is correct and these things are not braces but are in fact stocks, and as stocks are making SBRs, then it has been an SBR from the point you originally added the brace to your pistol. It does not become an SBR at the point that the ATF says now we think it is. It's always been an SBR if we accept the ATF's line of reasoning. Because the ATF is not saying, hey, there's a new rule moving forwards. They're saying we think these things are and always have been SBRs, and you've illegally possessed one. Now they're willing to waive their criminal prosecution. They're willing to allow you to register these items. And to register it, they want you to do an E-Form 1. This is the process that you would typically use to apply to make a short-barreled rifle. In order to apply, you're going to need passport-style photographs, you're going to need fingerprints, you're going to need notification to local law enforcement, and you're going to have to submit this to the federal government. Now, typically, there's a $200 tax associated with registering to make a short-barreled rifle. The ATF is kindly willing to waive that tax for people in the 120-day period between when this rule has been released and when it goes into effect. They say, if you register your weapon with us during that 120-day period, we're going to waive the $200 tax stamp. Now, this is also interesting because they are taking the position that the item is a short-barreled rifle today. And they're sort of saying, we're voluntarily not going to prosecute you if you can show us that you took this step towards registering it during this time period. Of course, that's not how it works for other things. For example, if I filed a Form 1 to build a suppressor, and then before I received approval, turned around and actually built the suppressor, and the ATF learned about it, they would absolutely want to prosecute me for that action, because generally you have to receive approval before you can follow through with building something. But here they're saying that you're making something that's already in existence. So some flaws in the way the ATF is looking at this, some flaws in the reasoning. However, there's additional issues with this registration. One of the additional issues with this registration is that they're only letting you do it as an individual. The issue with registering your pistol, which you lawfully possess as an SBR, as an individual, is that all of a sudden, a pistol that I legally possess, other members of my household, my loved ones, they could also possess that pistol. I could have it in a gun safe, my wife can access the gun safe, she can use the pistol. If it becomes an SBR, and it is registered to me as an individual, my wife cannot access it without me. What that means is if it's in the safe with all my other weapons and she can access that gun safe, all of a sudden she's now subject to liability as being in unlawful possession of a National Firearms Act item because she can access this SBR in my gun safe. Back when the ATF considered it a pistol, totally legal for her to go access it. Now that they consider it an SBR, if it's registered to me, I'm the only one who can possess it. Now, how do people get around this? Typically, they get around this issue through registering their National Firearms Act items in a trust, in a gun trust. And the benefit of registering them in a trust is that any trustee can also possess the items. So I put my National Firearms Act item into a trust, I make my wife a trustee, then both she and I can possess the weapons, and back to a situation where she can access the gun safe. So now we're on good standing, good firm ground. However, the ATF is not going to let you register your pistol as part of a gun trust unless you can show them that it was already in a trust prior to January 13th, 2023. That means if you own this pistol and the pistol's already in a trust, then sure, you can go ahead and register it that way with the ATF. If not, they're not going to let you register it through a trust. You're going to have to register it as an individual, meaning you're going to be the only one who can possess it. Other family members, other loved ones will not be able to be in possession. And when I say they're not going to let you, they will let you, but they're going to force you to pay that $200 tax stamp if you want to register it through a trust. If you register it as an individual in this 120-day time period, they are waiving that $200 tax stamp. And as I said, they make that sound like they're being very, very generous. Of course, they're making you jump through several hoops that you did not previously have to jump through to own this very same item. The item hasn't changed at all. The other option, people are going to come to me, they're going to say, well, Gilbert, I'm not interested in registering a pistol that I legally bought, that I legally possessed. I'm not interested in registering with that with the federal government. That doesn't sound good to me. I don't want to send them my fingerprints. I don't want to send them passport photographs. And they're right to be concerned, because once it's an SBR, in addition to the possession issues that I just highlighted, there's other legal issues. For example, a pistol, I can travel out of the state with a pistol. I can go to another state that recognizes my right to have that pistol. If it's an SBR, however, prior to leaving the state, I need approval from the federal government via Form 20. So we're starting to complicate everything, in addition to the concerns associated with the ATF building a registry of all the people that possess these items. So definitely some issues with registering it. So the other option for people is to deconfigure the weapon. Take it apart. Take the brace off the pistol, have the pistol separate from the brace. If you take this course of action, a couple things to point out. Number one, even though you have taken it apart, if the ATF ever really goes rogue and really decides to start prosecuting people, if they can prove you ever had it in a format where it was put together within the statute of limitations, they could still prosecute you, because their position is, at the point you had it together, it was a short-barreled rifle and you did not have it registered. So you take it apart. You need to be careful of a legal theory called constructive possession. Constructive possession is a legal theory where if you have two pieces and the only way they could fit together is to make an illegal weapon, then the ATF is going to charge you with possession of that illegal weapon, irrespective of whether the pieces are actually assembled as such. This means if you take the brace off and you still have the brace in your possession, but you have not installed it, the ATF could still prosecute you for possession of a short-barreled rifle, because they argue the only thing you could do with that brace is reinstall it and illegally make a short-barreled rifle. Final option for you that the ATF says is, hey, you can come turn it in at your friendly neighborhood ATF office. I'm not going to recommend this for anybody, because they're not offering you any immunity from prosecution. They are asking you, if that's the course of action that you want to take, they are asking you to give up a weapon that you paid good money for, that you legally purchased when you obtained it. And in doing it, you're turning over evidence that you possess something that they claim is a federal crime. So terrible idea to take it to a local ATF field office. Now, I know people are going to come to me and they're going to say, well, Gilbert, surely these actions must be challenged. And I absolutely agree. There's going to be multiple challenges filed. I don't have to be reading a crystal ball to know that these legal actions are coming. What are some of the things, what are some of the challenges that we might see brought? I would expect we're going to see separation of powers challenges, okay? People are going to be arguing that the ATF does not have the power to administratively reclassify these weapons that up to 40 million people own. And as part of this, you're going to see arguments under the Administrative Procedures Act. You're probably also going to hear talk about the Major Questions Doctrine. The Major Questions Doctrine stands for the proposition that if what is being decided is something that has a major economic impact, the courts should not defer to the agency's perspective. The court should not say, agency, we assume you got this right. Because it's going to have major economic impact, the courts need to take a fresh look at it. So separation of powers and impacting administrative procedures and Major Questions Act. The other one that I haven't heard other people talk about, but I think is an important one, is going to be the Fifth Amendment. And the Fifth Amendment has been looked at previously in the context of the NFA. Back in 1968, the United States Supreme Court heard a case called U.S. versus Haynes, or Haynes versus U.S. And in this case, they looked at a criminal prosecution for somebody who failed to register an NFA item. The crime at that time was a separate crime for failing to register an item that was subject to the NFA. And the United States Supreme Court in 1968 said, no, this is unconstitutional. It violates your Fifth Amendment rights to force you to come forwards and register an item that you can get in trouble for possessing. And after that, they rewrote the law. They created a new statute, 26 U.S.C. 5848. And this new statute has limits on prosecution. It essentially says, if you come forwards to register an item, that action of registering the item, either prior to filing or at the time of filing, cannot be used against you as evidence of a crime, all right? And so what's this do? It prevents the ATF from prosecuting you at the time of filing if you're going to register one of these items. What that statute does not address, however, is the time period after you file the application. And the reason this is important is because we know how long the waiting period is when you file an application, when you file a Form 1 to make an NFA item. The wait period is months, or at this point, if there's going to be millions of braced pistols filing, it might even be years. And this statute provides you immunity from prosecution up until the time of filing. It doesn't say anything for the time period after you file. Now, the ATF has said in their guidance that as long as you can show them proof that you filed the application, you can leave the weapon in the format it is. However, that's no official promise. We've seen them flip-flop on this stuff previously, and the penalties are very, very serious. So I think that there's a Fifth Amendment issue telling people to come forwards and register items that they currently own that the ATF says are illegal in the format that they currently own them. This is Fifth Amendment self-incrimination stuff, because if the ATF could use that as evidence of your illegal possession after the date that you filed but before you receive approval, then I think the Fifth Amendment is violated. So that would be something else that I would forecast as a possible legal challenge to what the ATF is doing here. There is a lot left. This rule is hundreds of pages long. There's a lot left to parse through. I'm sure we're going to have some more updates. In the meantime, if you've got questions about this, shoot me an email. My email is gilbert@amblerlawoffices.com. Again, that's gilbert@amblerlawoffices.com. Thank you.